purposes or whether you restrict that funding. Is that fair, Chairman Pitts? I guess that's really your question.
Could you repeat that, Mr. Chairman?
So your only control is the power of the purse, is either granting or rejecting requests for additional funding from the DA's office.
That's correct.
Okay. And that has to be based upon assurances presented to you by the DA as to why she would need particular amounts of funding?
Right. The DA can come before the board and make a request at any time, and we would consider the request, and if we agree, then we'll grant it.
Right.
If we disagree, then we won't grant it.
And in that request, do you require her to give some specifics? You know, some who I want to hire, why I need to hire somebody, how much I want to pay them, what's going to be the cap on their
We don't
service?
get into that sort of detail. I mean, she'll would make a case as to why the need is there and what it would cost. But as far as individual names and what the compensation for a given individual would be, we don't get that kind of detail, nor do we ask it.
Did DA Willis ever make a request for specific funding for a special assistant DA, prosecuting DA, for for Mr. Wade?
Not to my knowledge.
And is her position that she doesn't have to ask or provide that information to the county in order to make a supplemental funding request?
Well, again, with respect to the special prosecutor, that's solely the purview of the district attorney, unlike the outside counsel.
All right. But you fund the district attorney based upon her stated needs or her request for funding, right?
Correct.
Okay. In her budget request, does she have a category for special prosecutors?
I don't recall seeing a special category.
Mr. Chairman, I guess I would have to say that she as have prior district attorneys, have asked for resources, trial expense resources,
Right.
without it being specific to X amount for a special prosecutor or X amount for expert witnesses or, things like that. I think that it's been more like we know we have these major prosecutorial matters that will be moving forward and will require additional resources, but I don't recall there being any specific line item details necessarily associated with that.
All right, so we heard testimony at a previous meeting that there was a team of at least 10 assistant DAs working on an election interference case, and at least 3 special counsel that are being paid as independent contractors, including Mr. Wade. Was that ever described to the county commission in any of the funding requests?
I don't recall that coming before the board.
So she never came to you and said, I'm going to need a lot of money here to conduct this prosecution of, now there's 16 different defendants I'm going to call it the election interference case. Was that ever expressed to the county commission that that's part of why you were asked to give $36.6 million?
Again, not with that level of detail. So again, trial expenses.
Just generically, not even for the type of prosecution?
I want to say for the 23 budget, and I will have to go back and verify this, that there was some communication where she identified a need for resources because she expected to have to retry a case that had been a high-profile case, as well as the gang matters that she has. I think there are a couple of those, and the elections, the elections interference matter as well. But again, it was a lump sum, not specific with line item details.
Right. So you think that was in her budget request, perhaps in '23? Are we talking about Young Thug trial that's been it's gone on forever and ever so far, or different gang-related?
I believe there is more than one gang-related, large-scale prosecutorial matter. But yes, sir, that would be one of them.
And you think she may have also itemized the election interference case would require additional funds, or categorize that as an area of needed funding?
Yes, sir. Again, I would have to go back and look. Well, I don't, because.
You don't have to go back anymore. You've got your right-hand woman right there to help you.
So, yes, sir. That was Sabrina McTier, the county's budget manager. So this is from the '23 budget enhancement request, and the description says, and I'll just read it, the general rule: the more complicated a case, the more likely expert witnesses, e.g. professional services, are needed. That was in parentheses. State versus Tex MacGyver has been remanded to this office. This case alone cost $675,000 in professional services. I have this case and several anti-corruption cases that are being litigated in '23. It is sufficient to enhance this budget, and the request was $1.1 million.
So that was for Tex MacGyver and any other public corruption case?
Yes, sir. So that's the kind of description that I was perhaps not doing a very good job of expressing, but
you're doing great. And as far as your recollection, Chairman Pitts, is that she never named that she would need a special prosecutor on any election interference case?
Not that I recall, sir.
Certainly never told you the names of who she might be hiring or how much she was going to have to pay them?
Not that I recall, sir.
Did she make other budget enhancement requests back in 2023, 21, or 22? I can't remember exactly when she was sworn in. Y'all know that?
Madam DA was sworn in and began her term in 2021. So we did receive enhancement requests from her for the 22 budget cycle, the 23, and the 24.
Okay. What was the $5 million enhancement request for clearing up homicide backlogs? Do y'all recall that? That was testified to here last meeting.
That was a request that came through in the middle of 2021. She requested additional staff to support a number of items, the outstanding homicide situation being one of them. Ultimately, in 2021, through a budget amendment process that we call budget soundings, the Board of Commissioners did authorize her to have funding for an additional 55 positions.
Wow.
It was a mix of attorneys, investigators, and administrative support personnel. And in '21, the cost that was necessary to begin to onboard those positions, because she would not be able to do all 55 at one time, was less than $800,000. I think the budget soundings was $780,000 and some change. But the full annual cost for that is the $5 million. And so we built that in then to her 2022 budget with the full year funding for all of the positions that the board awarded her mid-year in 2021.
And was there any mention in that $5 million enhancement request that would be needed for any type of public corruption investigation?
I will have to go back to the source document to confirm that.
What do you call that source document? Because I'm going to want to make sure I have adequately identified what I need to be produced.
I would call it a budget soundings request.
Okay. And can you provide those to me without me submitting an additional subpoena? I think they're included in what I've asked for. I may not have been as specific because I didn't know what to call it.
Yes, sir. I had intended to include the 2021 soundings information as part of the request for the budget information that was already included.
You can just follow up and get that to me or Secretary Cook at your convenience. And if you would do that for any of those sounding requests for 21, 22, 23, and 24, just to keep me up to speed. Because, Chairman Pitts, what I am hearing from you is that the Board of Commissioners never got any kind of specific request for additional funding to prosecute any election interference cases, other than that generic 1 million, in 23.
Not that I recall, sir.
And no specific information about who needed to be hired as an independent contractor or what they would cost. I understand Governor Barnes was too expensive, and I just didn't know if that's that y'all figured that out or she ruled him out for that reason.
No, not that I recall.
I am subject to hire an amount.
He's a gun for hire if anybody out there is paying attention. And pleasure to have you in the audience with us today, Governor Barnes. And I'm just wanting us to get a feel and for exactly how much oversight there is. It sounds like it's very loose as far as employment practices and expenditures for independent contractors.
Yeah, that information doesn't come before the board.
Right. Only you have to peel it out in these soundings and in the annual audit and in the budget submissions as she gives you the categories of what she needs.
That's correct. And when budget soundings come before the board, there's a little more detail and more specifics.
Right. Probably pretty difficult politically for you and the Board of Commissioners to reject a request for needed funding to clear up a backlog in homicide cases, right?
Well, I mean, we had such a tremendous number of cases that were so-called, had been there for up in the thousands. And we decided that the $75 million from the Orca funds has already been referenced by Ms. Whitmore.
Right.
So in order to, we threw, $75 million of I think we received a total federal allocation of about $206 million in ARPA funds, and $75 million of that $206 million went to the justice system.
Right.
And the justice system meaning everything that the CFO has outlined.
So that was back in the fall of 2021. It was about the same time Mr. Wade was being hired. And it wasn't mentioned to you that any of the enhanced money was going to go towards Mr. Wade or any other special prosecutor to prosecute election interference.
No, it was my understanding that that $75 million was to be used for the justice system, and specifically, sort of specifically, to reduce the tremendous backlog that we had.
And there was a $5 million enhancement that was from county funds, not the Orca funds, or is that the same money?
Is that the same money?
No. The $5 million is general fund,
Okay.
county.
And in that request, that was on top of the Orca funds to get rid of the backlog of homicide cases.
Is that correct?
Yes, sir. She actually asked for over 100 positions. When she made the request, and the way in which we addressed it was we already had the backlog program in development, and so we identified a certain number that would be funded through the backlog project out of the ARPA resources, and the balance we provided for out of the county's general fund.
And this is back in the fall of 2021.
Yes, sir.
2 years before her 1.1 million request for public corruption and Tex MacGyver.
Yes, sir.
Okay. Did she ever report back to you the progress being made? What kind of bang you were getting for your buck? You're giving her tens of millions of dollars in either Orca funds or federal, state, county general funds to get rid of this backlog. Did she do it?
I don't recall any specific report back to the board from the district attorney. However, at each meeting of the board, we would receive an update on progress that was being made. That's accurate, isn't it?
Yes. Yes, sir. As part of our global pandemic response, we presented the Board of Commissioners with an update for a while at every board meeting, and then eventually at just one meeting a month to update them on our progress using our ARPA resources, and specifically on the backlog project, showing total backlog cases, progression of those cases through the system. And so we've been reporting on that regularly up until February of this year due to our cyber incident. So we are almost ready to begin that reporting process. Again, the last report that we made of the progress of Project Orca was in January, at the second meeting of the Board of Commissioners in January, and that was for progress through the end of 2023.
So would that list the number of homicide cases that are pending and how many are being resolved on a monthly basis?
It doesn't list case type. It lists the total number of projects, the total number of cases by each of the players, if you will, the solicitor, the in the magistrate court, the district attorney, and then Superior Court and State Court. So we kind of track the progress of the cases from the two prosecutors, from the solicitor and the district attorney, into their respective courts, and then we track the progress that the courts themselves are making in fully adjudicating the cases. So that information is all presented to the board in a chart and discussion, and what's happening, all the various different things that we had to do in order to see that line make the progression that we were looking for.
So how many backlog cases were there? Do you have a ballpark figure how bad this got back in 2021? We're a year into the pandemic, courts are not trying cases, and oh my, you got a full color report there. Is that in my notebook?
We'll get an exact number. It was.
We started our drop date that we used to define our backlog cases was December 6, 2021,
Okay.
And we started with a total of 148,209 open and active cases in any stage.
That included solicitor's office
Yes.
that prosecutes
Yes.
misdemeanors.
Across
and
the justice
DA's
system.
office that prosecutes the felony offenses.
Yes, sir.
Does it break them out, how many are state court versus superior court?
The state court, the starting point for the state court was 20,124.
So the vast majority of them, or at least 2/3 of them. What's the superior court?
Superior Court was 15,888.
Okay. Then you got magistrate courts as well, I guess.
Magistrate Court was 39,435.
And that can be everything from a speeding ticket to parking ticket, very minor things.
Variety of,
Okay.
yes, sir.
What else you got? Municipal court, I guess?
The Solicitor General had 56,462 at the starting point. And the District Attorney had 16,300.
Okay. Where's the 16.3 now, or at the end of 2023? Has it been Has the DA used all these millions to any good to catch up?
From our report in January, the district attorney's number was 130 cases that were the original Orca. So this is only tracking the cases that were considered in the Orca backlog that started at 148. So again, these resources were only supposed to be focused on reducing those cases. There were still new cases, of course, that come into the system since that point in time.
Right.
And this report does not talk about those. This is specifically focused on those Orca cases.
Those new ones are not funded through the Orca funding.
Correct.
Okay.
Correct.
That makes sense.
Repeat those two numbers, the start
What-
in January.
For who?
The start for the DA, you started at 16,300 and ended up with 130?
Yes, sir.
Okay, and that was from fall-
December 6th of 2021 through 12/31/2023.
And we can't discern whether they're dismissed cases, whether they're plea bargain cases, or trials to a verdict.
Not from this report, no,
Okay.
sir.
They just got out of the system, resolved one way or another.
So for the district attorney, they were either moved on to Superior Court, which is where her cases would typically go, which means she still has to then prosecute them. But what we were tracking is, the cases that she had where, they were still sitting in, per se, in her queue, if you will.
Yeah.
So from 16.3 down to 130, they either moved on into the further into the prosecutorial process, or yes, they were dismissed, or whatever the other term is that you would use when a court case doesn't progress, when a matter doesn't progress.
Did your reporting requirements for these Orca funds require any detail as to the successful completion of a case, whether there was a conviction or a plea, or they just dismissed it, or did they break it down for you that way? Or just one lump sum number of these cases are resolved, they're no longer in our system, in our queue?
We did not require that level of reporting to the Board of Commissioners. We do have, I believe, that level of reporting from our criminal justice system, but it's just not included in what we reported to the board.
And does that criminal justice system of Fulton County prepare a report giving those annual updates or dispositions of cases?
They have not. This is something that the executive team worked on. For Project Orca, there was a steering committee that was established that, like the chief judge of Superior Court, chief judge of State Court, magistrate court, chief judge, the clerk of Superior Magistrate Court, they all participated in the steering committee process. Our former COO, Alton Adams, guided them through that process. So there was no explicit reporting requirement for that detailed level of information made by the board to the group, but the board did want to see, the results of their efforts. So, Mr. Alton worked with the judicial partners in developing the information that was reported back to the Board of Commissioners.
Yeah. So you think that criminal coordinating council, or whatever they're called, kept data that specific as to the outcomes of the cases?
I think it's in our system and can be pulled out. I don't know. I didn't participate in those sessions, so I don't really know what they did with that information.
Who would you recommend me asking to pull that data out? Who should I submit a request for, ask to come testify to us?
Yeah, probably Alton, isn't it?
Perhaps Mr. Adams, Alton Adams.
He's no longer the COO?
He is semi-retired. He is continuing to work with the county
Contract.
as a fee-based employee to help us move further down the road with the potential replacement jail project.
Okay. Mr. Adams a fee-based employee? Does that mean he's still working just on an hourly basis?
Yes,
or
sir.
kind of a consulting type thing?
Project, more specific to the project, the replacement jail project.
Okay, so that's the project, replacement jail project?
Yes, sir.
Okay, thanks. All right, this might be a nice time for a little break. Would you guys appreciate or need a little bathroom break, a little stretch your legs type thing? We're going to recess for about 10, maybe 15 minutes here, and then I'll try to start wrapping some things up. But I know it's a broad range of questions, but you're helping educate our committee. Thank you so much. We'll take a break. We'll accommodating this little break, keep everybody comfortable, and we will try to forge ahead here in short order. My intention always is for these meetings to last 2 to 3 hours. I think you kind of lose your energy if we go much longer than that, and it's such an imposition on you witnesses that have agreed to come. So we'll try to wrap this up in about an hour or so, and making good progress so far. I want to finish up a few of my thoughts, sort of the traveling down certain roads, and then Ms. Joe, I want to get you to give me a little information from the county attorney's perspective, so I'm happy to have you sitting there. Okay, Mr. Pitts, we were talking about the special outside counsel, the approval of it, and essentially this Orca project and what its goals and intents were, and how it has successfully eliminated a lot of that backlog of the criminal cases that piled up during COVID. So you, as a commission, dedicated significant resources, both from the federal ARPA funds and from the county's coffers, to help staff up the DA's office in order to work through that backlog of cases, we'll call it. Mm-hmm. Fair enough?
Yes.
Okay. And it sounds like there was some accountability, at least telling the reduction in the cases, right, Ms. Whitmore, from what you were telling us. They are reporting on a regular basis as the progress that was made on those cases?
Yes, sir.
Okay. Maybe not as specific as I would love to see as what the disposition of the cases was, but we might be able to find that out through this other counsel. You got to tell me the name of it again. The judicial court system. What was it called?
It was the steering committee for Project Orca.
All right. And they would probably be able to give me a more thorough explanation of what happened to those cases.
Yes, sir.
So basically, was the DA's office good stewards of the funds that you allocated to them to accomplish the purposes that you gave that money for? Is that fair enough to say? We're trying to monitor that somehow?
Through the reporting, yes, sir.
Okay. You could leave that microphone instead of having back. So, Mr. Pitts, I'm summarizing briefly, but it sounds like the DA has pretty wide discretion how they spend the money that you appropriate to them, and does not have to basically get any type of pre-approval for hiring independent special counsel to assist in the activities of the DA's office.
That's correct.
Okay. And doesn't have to even report back to you how the money was spent or who was hired as a independent contractor and how much they were paid.
That's correct.
Okay. Did the previous DA seek prior approval or use this mechanism of special prosecutors?
Sure. Oh, did he? I can't remember, Paul. I don't recall the previous Mr. Howard.
Yeah, and Paul Howard was
right.
the DA for what, 20 years or so, right?
Quite a while.
Yeah.
Ever have using a special prosecutor? He could have. I just don't recall.
Okay.
You?
No, I don't. I don't recall. I would have to research that.
Would you take a look at that? Because I haven't uncovered any use of special assistant district attorneys by the prior district attorney who was in office for a couple of decades.
Yeah, I believe that request number 12 at least would cover 4 years of Mr. Howard's tenure.
All
And
right.
it's for outside counsel by the Office of the District Attorney from 2016 to 2020. So I think that would cover that that item.
You would be able to ascertain whether he had ever even utilized this device or this mechanism to sort of bolster his manpower in the DA's office.
During that period of time, yes, sir.
Okay. And I didn't want to be overly burdensome and ask you to go beyond 4 years back, because I think that would capture the contrast between the two administrations. Okay. So, Mr. Chairman, are you satisfied with the transparency and the disclosures, or the kind of keeping you in the loop by the DA's office on her use of special prosecutors?
Well, I mean, we've never had this situation before. I just don't recall under her predecessor, Mr. Howard, using a special prosecutor. So this is sort of new territory. Now with outside counsel, that's different, because that is recommended by the county attorney.
On behalf of the county?
Yes.
In civil matters?
Yes.
Okay. But you don't have recollection in all your years of service of previous DAs ever utilizing a special assistant district attorney?
Not that I recall, no, sir.
If they did, it was never brought to your attention or disclosed or publicized so that you would know about it?
That's correct.
Okay. And I think your position is that as a board, it's been communicated to you by the DA's office that she does not need your prior approval of such contracts.
Well, let me make sure I understand that.
The DA doesn't feel like she needs the prior approval of the county commission to hire independent contractors.
Well, technically and legally, she does not with respect to special prosecutors under these very, as I understand, very narrow circumstances, and I'm not sure how that's defined.
Well, let me help you with that, because this process is set forth in the Official Code of Georgia, annotated Title 15-18-20, and I'll just read it into the record here. Under subparagraph A, the district attorney in each judicial circuit may employ such additional assistant district attorneys, deputy district attorneys, or other attorneys, investigators, paraprofessionals, clerical assistants, victim and witness assistance personnel, and other employees or independent contractors, as may be provided for by local law or as may be authorized by the governing authority of the county or counties comprising the judicial circuit. Now, Fulton County is a single county judicial circuit, right?
Yes, sir.
Okay. And so you are the governing authority as the Board of Commissioners of that county.
Yes, sir.
Okay. And what you're saying is that you have never authorized her hiring independent contractors to assist in the prosecution of her duties.
That's correct. It wasn't required.
Well, this law requires it, but the county did not require it?
Well, the distinction, again, that I make is a distinction between outside counsel and the special prosecutor. It was always my understanding that the district attorney had the authority to hire a special prosecutor as he or she saw the need to do so.
Yeah. And that's the position that Ms. Willis has stated to you as chairman of the commission, that she was not required to get prior approval or authority to hire Mr. Wade or anybody else for that matter.
Well, I didn't have a direct conversation with her about that, but that's just the way it is, and the way our understanding was that because it's a special prosecutor, it did not have to come before the board for approval. And I was asked that question quite a bit by the members of the media. Said, did this have to come before the board? And in researching it, we concluded that it did not.
All right. I'm going to ask your county attorney to help me with that research, because she and I have had conversations about any court interpretations of this statute as we flesh that out. As the commission chairman, would it be your preference that DA or other constitutional officers should seek your approval before hiring independent contractors that you are responsible for paying for?
Yeah, that's the difference. Repeat that, let me make sure I understand you, sir.
As the county commission chairman,
Yes, sir.
would it be your preference that the district attorney did have to seek your approval before going out and hiring special prosecutors or independent contractors? If you're paying for it, or your general fund is.
Well, but under the, the current law, as I understand the current law, as it relates to constitutional officers and this, and the district attorney does not fall under that like the sheriff
Okay.
and the others do, but sorta, and she's sort of a state constitutional officer, as I understand it. It's a little
So
different.
part of the job of this committee is to determine whether we need to change the law. If it's unclear in this case, and I'm wondering if you are the lawmaker here, would you like to see state law changed so that a district attorney would have to ask your prior approval before going out and entering into contracts with special prosecutors?
Well, probably my opinion may be a little different because I focus on the money, and I'm always
Right.
want to follow the money from a fiscal conservative and like to know how the money is being spent. But with respect to a district attorney hiring who he or she believes that they need to, I mean, I don't have any issue with that, but I would like to know how the money is being spent.
So
Not
we're-
who, but
we're-
how.
We're back to the keeping you informed and the transparency of this process. If a DA is allowed to unilaterally hire whomever they want to at whatever price they want to pay them, do you feel like the county government ought to be able to be kept in the loop on this and reported to as to how your money was spent?
Well, in the loop, yes, there's no doubt about that.
Okay. And you don't feel like this process has been transparent so far?
Well, to the extent that we have not, we were not advised of the hiring of and not that it was required, of a special prosecutor, nor the payment, hourly rate or whatever the rate was. I mean, we were just following the law, and obviously I'd like to have more information, but that was the law at the time, and is the law at the time, as I understand the law.
In your opinion, has DA Willis been forthcoming or transparent with you and the commission as to her utilization of special assistant district attorney in this election integrity case?
Well, to the extent that this is all new ground for us and for all of us, and
And that's because it wasn't utilized by the prior district attorney for the last 20 years before her election.
well, this whole issue with election integrity, election interference, and all of that is new territory for us, and we're sort of, feeling our way as we go through this, even with the trying to work down the backlog of cases that we had. So
Do
we
you
were
worry?
sort of making up rules as we went along, to be honest with you.
Sure. Do you worry that she was utilizing resources for prosecuting a election integrity case rather than getting rid of this backlog of 40,000 criminal cases?
Would you repeat that?
Does it worry you that she was spending significant resources without prior approval or even any reporting or accountability pursuing an election integrity case rather than working on this backlog of 40,000 criminal cases that were pending in Fulton County? It might have been 56,000. I can't remember all my numbers. It was a lot total.
Well, as I said earlier, and as the CFO said earlier, we appropriated $75 million of the $206 million of the ARPA money that we received to the justice system. And she had, in addition to the backlogs, she is currently involved with the YSL case and the election interference case. So those were, I mean, three really unusual cases that I had never experienced before. So we were trying to be as helpful to her as we can and could by providing, for the most part, the resources that she asked. But as far as what happened to the resources, the money, when I say resources, I mean the money that we gave her, we, after it was given to her, we tracked the cases, the backlogs, and the jury is still out on the YSL and the election interference. So it'll all come out in the wash, I suppose, as to how effective it's all been.
And when
but we provided what was asked for, and we've not asked for, nor have we been provided any interim reports as to how we're proceeding, other than with the backlogs.
So she hadn't really told you how she spent the money?
No, sir.
Okay, so you gave her $75 million plus at least another
Well, it
$5
wasn't
million.
just to her, there was a whole justice system at $75 million. Right?
That's
Yes,
correct,
it wasn't
right.
just to her.
You gave her many millions of dollars to get caught up on a backlog of criminal prosecutions.
Yes.
Okay. And when you did that, there was no mention of any election integrity case, was there? That didn't really ever come up specifically, just this one sounding for additional money in 2023.
I believe that's correct. When you say
Which
that's
is-
correct.
Yeah.
The 1.1 million for Tex McGyver and public corruption is the only thing that could specifically have reference to an election integrity case.
In her enhancement request, yes, sir.
And it wasn't in her budgetary request either, was it? Anything about election integrity?
It would have, if it was for additional resources, it would have come through as an enhancement request.
So as a commission, you weren't aware that you were funding a election interference case, certainly not before 2023, which would have been 3 years after the election. That's
I think that's correct.
okay. And you haven't been given any information to tell you where the money that you did give her through Orca funds or other things were spent.
Well, whatever part of that $75 million that she received, and whether how much was used for the backlog, how much was used for the YSL case, and how much was used for the election interference case, and we don't know.
Yeah.
And we're not being given any information other than with the backlog. Now,
Is
that's probably easier to quantify. I don't know how she would give us, or any district attorney for that matter, would give us a report on how the case is going until it's concluded.
Understood.
Yeah.
But she could have told you how your money was being spent that you had awarded to her, whether it was being spent on the backlog of cases versus public corruption cases versus, Tex McIver or whoever. She would have been able to give you that data,
Could have, yes, sir.
but she didn't.
Did not, and we didn't ask either.
Okay. And that's partly because she's taken this stance that she's a constitutional officer and doesn't have to give you that information.
That's probably a correct statement.
Okay. Well, let me turn to you, Ms. Joe. You and I have had conversations before today about whether or not a district attorney has to get prior approval and authorization of funding from the county commission when utilizing this independent contractor, special prosecutor device that the legislature gave the ability through Title 15-18-20A. You heard me read that relevant portions of the statute, and you would agree just at face value that would seem to require a DA to obtain approval from the governing authority before hiring an independent contractor?
Yes, sir.
Okay. But I think, I'll make sure you're on.
I would agree that the plain language of the statute certainly seems to indicate that the governing authority needs to be consulted and approve such an appointment.
All right, now, so tell us who you are. You're the county
sorry.
attorney. Give me just a little bit of background on you.
My name is Sue Joe, and I am the county attorney for Fulton County, which means that I am the essentially in-house general counsel for the corporation that is Fulton County. And my office handles civil matters for the entire county, provides defense and legal advice and counsel to the Board of Commissioners.
And in your role as county attorney, were you ever asked to interpret this statute or do legal research to find out whether or not Ms. Willis should have gotten prior approval or whether she was required to do that before going out and hiring independent counsel?
I don't recall if there was a specific request, but of course, I keep up with current events, and when this issue came up, I did have the occasion to look into the matter and research it.
Give us your legal opinion as to whether or not prior approval is required. You've agreed that the plain language of the statute would indicate that. Have there been judicial interpretations of this statute that cloud those matters?
So let me begin by saying that the statute, OCGA 15-18-20, that you were reading from, deals with assistant district attorneys. So it's not explicitly giving the DA permission to appoint special district assistant district attorneys. In case law, that statute
It does
has
say
been.
independent contractors, though, right?
It does,
Okay.
which we, that is the classification for special prosecutors in Fulton County in terms of how they're employed.
Is there another statute that specifically addresses special independent counsel or prosecutors, whatever the phrase?
I have not found one. And what I was going to say is that the case law that I have reviewed that has interpreted this statute says that while it is not explicitly mentioning special assistant district attorneys, that is included in the general authority provided under the statute to district attorneys. So in at least 3 Georgia Court of Appeal cases, what I have found is that the court has rejected the proposition that this particular statute requires a district attorney to obtain explicit permission from a county prior to appointing a special assistant district attorney. And in fact, the original case, the court noted that
Give us that citation, because
So
this
that-
is kind of instructive to the legislature. Do we need to amend this
Clarify.
statute to clarify? And so you help me with my legal research. What's that citation?
So I'm sure the Attorney General's office would be happy to provide their official advice. But what I will, I'll begin by just saying what the citations are of the 3 cases that I reviewed. One of them is Greater Georgia Amusements at 317 Georgia Appeals 116, which cites to State versus Cook at 172 Georgia Appeals 433, and is referenced again in Amusement Sales Incorporated versus State of Georgia. And if you'll excuse me, let me look at my Westlaw. Okay, that's going to be at .316 Georgia Appeals 727. And all of them include a construction of OCGA 15-18-20 that indicates the DA does not ADA does not have to have explicit permission from the county in order to appoint a special assistant district attorney, and that the employment may be pursuant to whatever private arrangements regarding compensation are mutually agreeable to the district attorney and the appointee. That is a quote from State versus Cook that is contained in Greater Georgia Amusements.
So judicial interpretation of our statute essentially eviscerate the plain meaning or language of the statute?
Well, I will say I was definitely surprised at the construction in that it seems to be at odds with the plain language of the statute, but that is the current state of Georgia law as far as I can find it.
Okay. And in your role as county attorney, do you seek approval from the Board of Commissioners for hiring, we'll just call them outside counsel, to represent the county's interest in certain civil matters?
Absolutely. That is considered, that travels under a separate ordinance regarding the engagement of outside counsel. So for example, it could be an official of the county is sued, requests representation. If there is some reason why my office doesn't have the capacity to take it on directly, I may recommend the engagement of outside counsel, and I will bring that to the Board of Commissioners for their approval.
Okay. And that's pursuant to a county ordinance that requires that type of approval of both funneled through your office and submitted to the county commission?
Yes, sir. The Fulton County Plan of Defense governs what types of circumstances in which we can provide defense as a county, and also the way in which that provision is made. It is either made through my office or through outside counsel. Even if it is provided through my office, I still go to the Board of Commissioners, present the case, indicate why it's covered under the Plan of Defense, and ask for authority to represent.
Is there a similar county ordinance that references or applies to prosecutors?
There is not.
Okay. So you only refer back to the state law for that?
Yes.
Okay. In your role as county attorney, are you responsible for responding to open records requests?
Yes, the custodian of records was established in recent years and centralized as an individual who's designated from among the attorneys in my office.
So that is an attorney that responds to those complaints?
It is an attorney who
request.
oversees the
Production.
response operation.
So that's under the control of your office then, or?
The intake and coordination of the response is within my office, the county attorney's office. Obviously, we are not the custodians of most of the documents that are requested, so we have to coordinate that, with designated open records liaison within each custodial department.
Do you, in your office, respond to open records requests submitted to the district attorney's office?
She has the ability to handle the entire open records process separately from the county as a state official. Historically, the district attorney's office has both utilized my office as the point of origin and liaison, and then at times has chosen to opt out of that. Currently, this district attorney for Fulton County does receive her Open Records Act request through the Open Records custodian in my office.
And if counsel is needed to respond to those requests or object to them or litigate disputes over open records requests, is that something provided by you for the district attorney, or does she handle that herself?
So having it routed through my office is a fairly recent circumstance with our district attorney's office, but now that it is within my office, any questions as to exemptions and what is subject to public disclosure under the Open Records Act would be referred to my attorneys in my office, and we would assist with that and provide guidance.
And is your office actively providing guidance or legal counsel to the DA's office in any open records request or litigation arising from those at this time?
At this time, yes.
Okay. Does she opt out of utilizing your services on occasion? handle them in-house, so to
So
speak?
I did not mean to imply that it was a case-by-case basis. There was a period of time in which the point of contact was not my office. My office was not involved in the process. But as of, I would have to check to confirm when, but it would be at least several months ago, perhaps a bit longer. She has opted to utilize my office as the initial point of contact and to provide that type of guidance again.
Was she using your office for a point of contacts and guidance and sort of legal services during the open records requests that Ashley Merchant submitted this past fall?
I would have to confirm that. I don't know exactly when that came in.
Okay. But here in the last few months, District Attorney Willis has begun to utilize your office as the point of contact for receiving open records requests and for responding to them?
That's not exactly accurate. For receiving and for coordinating and providing advice, but in many instances, the custodial departments will upload their own responsive documents. So when we advise them of what is being requested, provide any legal guidance that may be necessary, are a point of contact for communication to provide status updates to the requesting party. But because the custodial department may have more immediate access, or if it is in the case of voluminous responsive documents or documents with restricted access within those departments, the department itself is often the ones who will upload the documents into our software that is used for Open Records Act requests.
So if I submit tomorrow an opens records request to the Fulton County District Attorney's Office, maybe I want to find out what happened to those 16,000 cases that Orca was supposedly funding. Who will respond to that? Does the DA's office respond to me, or do they route it through you and you give me a response?
My expectation would be that someone on the Open Records team in my office would be the initial point of contact and say, thank you for your request. We understand you've requested XYZ documents. Either here are your documents, or we estimate that it will take a certain amount of time to gather the documents that we believe are responsive and within our custody. And then that they would keep you updated or be available should you call in or email in with a question as to status.
And if the district attorney did not want to provide the documentation I requested, would she object to that, instruct you to object to that, or does your office make that determination?
So I don't know that we have a long enough history to have representative sampling of all the different potential circumstances, but my expectation of the process would be that we would communicate what was requested, that her office would identify whether or not they had responsive documents, and that they would work with my office to identify the subset of those documents that do not fall under any type of exemption, for example, pending investigations or any of the statutory exemptions that are provided for in state law.
Okay. And so what happens if she says, I ain't giving that information up?
I am not aware of such a circumstance. In some instances, the response we get from the departments may include, we do not have any responsive documents. And that is how sometimes disputes arise, because the requesting party may believe that they exist, and the custodial department asserts that they do not exist.
Okay, what if they say, yep, they exist, but nope, I'm not giving them to you? You know they exist, your custodial people figured it out, it's public records.
To my knowledge, that response has not occurred. But if it did, I would expect my Open Records team to review the statutory obligations under the Open Records Act with the custodial department to emphasize and impress upon them their legal obligation to provide the documents that are subject to the Open Records Act.
Okay, thank you. Let me ask you about the county ordinance concerning reporting of gifts from vendors or independent contractors. Does Fulton County have such a policy?
I believe, and I haven't reviewed that specifically for today, but I believe you are referring to the prohibitions that are contained in our ethics code.
Yes. So
Yes,
What does your ethics code of Fulton County provide as far as the receipt of gifts from independent contractors or other vendors of the county or its agencies?
I mean, if I could have a moment, I could try to pull that up, but just off the top of my head from previous reviews, there's a lot of language in our ethics code about appearance of impropriety, appearance of conflicts, avoiding appearance of conflicts. So my advice, if I were asked, would always be to avoid it altogether. However, there are certain customary gifts, chocolates at Christmas time, Christmas gifts, etc., things that are shared among everyone in the office. As long as it's of nominal value, and I believe the cutoff is $100.
That sounds
There is a nominal value that is allowed under our ethics code, but anything of significance beyond that is considered to be prohibited.
And is it prohibited to receive it, or are you required to report it?
I can't recall if it's a report. I want to say it's a reporting requirement, and the reason I can't recall is because I like to stay as far away from the line as possible, so my preference would be to not receive it. But it may be a reporting requirement. If you would like a certain answer, I can check either on a break
Sure.
or at some
I'll
point
let
in
you
the
do that
proceedings.
for me.